let me just first of all thank QED for keeping alive this debate on benchmarks, which is worth doing not just because of the possible difficulties with implementation of this new regulation, but also for the news awaited for the next couple of years, I would say, mainly in the area of the known critical benchmarks, a new methodology for the calculation of the Euribor, and possibly also a substitute for the EONIA, given the setting up of a working group dealing with, also in Europe for the first time, dealing with the task of finding a risk-free reference rate. I also want to thank Anne-Claire for having taken you through some background on the ESMA network work at this stage. So this actually allows me to go straight into the focus of my presentation, which is about the transitional regime within the benchmarks regulation and the consequences, this have on the various addressee of this regulation. These are the provisions included in level 1. As you can see, there is a transitional regime which is laid down in Article 51, but I also wanted to draft Article 34 because I think that as far as the position of index providers vis-à-vis this regulation is concerned, these two articles need to be read in combination. In my understanding, Article 34 is something which is due to apply in the ongoing. So after the regulation entering into force and at the end of the transitional period, both a newcomer or an already existing index provider, when it becomes aware that one of the index provided is referenced in a financial contract or a financial instruments or to measure the performance of an investment fund as specified in the regulation, will be compelled to apply for either an authorization or registration within 30 working days. But how to read these in combination with the transitional regime, which allows an already existing index provider at the time this regulation kicks in, other 24 months before applying to its national competent authority to be authorized or registered. This was actually the most debated issue since the, I would say, the finalization of the work on the level 1 text. The transitional regime sets out in Article 51 as implication, I would say, not just for index provider, but also for contributors and for users. For users, you know that these are bound to choose, after 1st January 2018, only benchmarks provided by administrators included under the Article 36 ESMA register or third country benchmarks included in that register. But as a result of the transitional regime, which apply both to EU-based index providers and to extra EU index providers, that register will not be stable until 1st January 2020 and even beyond. So from when supervised entity will actually be in a position to be sure to comply with Article 29 of the regulation? This slide shows the timeline. 30 June 2016, when the benchmarks regulation entered into force, 1st January 2018, when it entered into application, and 1st January 2020, which is the end of the transitional period. So from 30 June 2016 until 1st January 2020, Article 51 specifies that supervised entities can use existing benchmarks until 1st January 2020, or even beyond, unless and until the authorization registration of a provider is refused. After 1st January 2018 and before 1st January 2020, existing index providers, but also newcomer, may apply for authorization registration, and the benchmarks register is going to be populated after 1st January 2018. And I don't know if you had the chance to check on the ESMA website. There are actually already 6 administrators having been either authorized or registered by the FCA and subject to its supervision. And then after 1st January 2020, supervised entities can continue using existing benchmarks not included in the ESMA register only if the authorization registration process is not completed, or if the relevant competent authority has adopted a decision under Article 51.4 to allow the continued use of a no-compliant benchmark. So the main question for the industry was, after the publication, but even before the publication of the regulation, for an existing index provider, would it be possible between 30 June 2016 and 1st January 2020, but in particular between the entry into application of the regulation and the end of the transitional period, to launch new benchmarks? Because particularly for the most active administrators, the activity requires the continuous production of new benchmarks. So how to interpret the provision in paragraph 3 of Article 51? Well, ESMA has based its reasoning, I mean, the people in the network group base their reflections on the term existing benchmark, which is used in paragraph 3 of Article 51, coming to the conclusion that these words, existing benchmark, should be understood as existing on or before 1st January 2018, in light of the fact that actually Article 51.3 is only applicable as of 1st January 2018. Based on that, it was clarified by ESMA that an index provider existing as of 30 June 2016 is allowed not only to continue the production of the benchmarks already provided as of that date, but also to launch new benchmarks until 1st January 2020, and supervised entities as well are allowed to use those benchmarks in full compliance with the regulation. But then the network was also faced with some questions coming from 2 or 3 competent authorities, having the practical, the concrete case of index provider taking over the production of an existing benchmark but being new to the business. So an additional part of the clarification provided by ESMA was aimed at dealing with these specific cases, and in that respect it was specified that if a new index provider starts to provide benchmarks between 30 June 2016 and 1st January 2018, it might continue to provide benchmarks until 1st January 2020, even not applying for an authorization registration, and also to launch new benchmarks, not only to carry on the provision of the ones already provided. But if a new benchmark is launched after 1st January 2020, that's where Article 34 kicks in. So that's become already like it was an ongoing situation. So the index provider, for the circumstances of not being already active at the time of the entry into force of the regulation, but as being a newcomer, if it decides to launch a new benchmark after 1st January 2018, it is considered like any other newcomer started the business after the new regulatory landscape at the European level. The Q&A on the transitional regime for the EU index providers were the first one to be published by ESMA, because as said, there was a significant request by the industry to have clarity in that area. But the second area was the application of the transitional regime for no-EU index providers, so it was the second Q&A to be published. In particular, paragraph 5 of Article 51 was drafted in a slightly different way than paragraph 3, I put emphasis on the words where the benchmark is already used in the Union, because that is considered the precondition for third country benchmarks to be used by supervised entities until 1st January 2020 in full compliance with regulation, even if the third country benchmark is not yet included under the ESMA register. But why this? This has been done according to, I would say, holistic and pragmatic approach by ESMA, so as to align the transitional regime for both EU and no EU index providers, and not to create, with a view not to create a differentiation in the application of the transitional regime for these two categories. But there is, in any case, a difference which is embedded in the level 1 text, because for a benchmark, for a third country benchmarks to be used after 1st January 2020, the only possibility is for the financial instruments, contracts and investment funds already referencing to that benchmark before that date. So there was also a question about what if the third country benchmark is no more used? I heard this question by the industry, but this question, it would be relevant only if the use of a third country benchmark was allowed also for newly issued financial instruments or for new contracts or investment funds, but this is not the case. So ESMA just clarified that the date which really matters is that of 1st January 2020. At that date, a third country benchmark is either used or not used. If it is used, it might be continued. The use may continue only for those financial contracts, investment funds and financial instruments, which started to reference it before. There are two Q&As only recently published, but which in my understanding are very much related to the clarification ESMA provided on the transitional regime. Because having clarified the position of existing index provider vis-a-vis regulation until 1st January 2020, the connected question is how to comply with regulation, or is it important? Is it binding for an index provider to comply with the regulation? Reading Article 34, we found already the answer, but we try to clarify in a Q&A. This is not actually required, because Article 34 says that an index provider will have to demonstrate its national competent authority to fulfill all the conditions set up in the regulation at that date, and at all times after the date of filing the application. So this means that before submitting an application to the national competent authority, an existing index provider is not due to comply with the regulation, even if the benchmarks provided as a result of that provider benefiting of the transitional regime might be used by supervised entities within the Union. Another very much connected Q&A, in my view, is that concerning the position of users vis-a-vis the regulation during the transitional period. The question actually was, are supervised entities bound by the requirement in Article 28.2? Well, we couldn't find any legal hook in the level 1 text to say no. So as of 1st January 2018, supervised entities are required to comply with Article 28.2, which implies for them to draft so-called contingency plans to say the actions they will take in case of cessation or major changes to the benchmark they choose to reference, specified in the regulation. In my understanding, not only the clarification that Article 28.2 is applicable since last January is formally aligned to the level 1 text, but it is also quite logical and and as I anticipated, very much linked to the clarification about the regime applicable to administrators during the transitional period. For example, during that period, an index provider, not yet authorized, is not bound to the transparency requirements concerning, for instance, the major changes to a benchmark that it should otherwise disclose as part of the methodology or in the benchmark statement. So I personally think that it is of the utmost importance that the user works out on their own which are the actions to take in case of major changes, because they cannot benefit of this transparency. Especially in the perspective of ensuring on a continuous basis the suitability of the benchmark chosen to the benefit of their clients. Thank you.